Britain erased 14,000 people for refusing an oath. Birmingham, England, April 2024. The letter arrived on a Friday afternoon, 5 o'clock, just before a bank holiday weekend. Amina had been living in the hotel for 11 months. She shared a room with her sister and two small children, sleeping on a fold-out cot that dug into her back each night. The carpet was stained. The window faced a brick wall, but it was shelter. And shelter was more than she had in Damascus. The letter was thin, official, stamped with the crest of the Home Office. She opened it with trembling hands. Notice of intent. Your asylum claim has been declared inadmissible. The Secretary of State is considering your removal to the Republic of Rwanda. She read it 3 times. Rwanda. She knew nothing of Rwanda except that it was in Africa, somewhere south of the Sahara, a country whose name she had never spoken aloud. You have 7 calendar days to respond. Amina had fled Syria because her brother had been taken from his home and never seen again. She had crossed the Mediterranean in a rubber boat that nearly capsized. She had walked through 4 countries with a child on her hip. And now, this. A letter, 7 days, and the threat of erasure. She did not know it then, but she was one of more than 24,000 people who would receive such a letter. And of those, nearly 14,000, by some counts, more than 18,000, would find their cases effectively erased, their claims placed in a legal purgatory from which there seemed no escape, all because they refused to accept that their fate should be decided not in Britain, but in a country whose asylum system had rejected 100% of applicants from Syria, Afghanistan, and Yemen. They called it the Rwanda policy. But the people who lived through it called it something else, the erasure. The history of Britain's Rwanda policy begins not in Kigali, but in London, in the spring of 2022, when Prime Minister Boris Johnson stood before a bank of cameras and announced a plan that would, he promised, break the business model of people smugglers once and for all. The policy was simple in conception, monstrous in execution. Any person arriving in the UK by irregular means, by small boat across the English Channel, hidden in the back of a lorry, clinging to the underside of a train, would be declared inadmissible to the British asylum system. Their claim would not be heard in London. Instead, they would be removed to Rwanda, a nation on the African Great Lakes, where their application for refugee status would be processed under Rwandan law. The government called it a migration and economic development partnership. Critics called it a 21st century UK-Africa trade, and people seeking asylum, men, women, and children who are the sentence unfinished, trailing off into outrage. But the mechanism of the policy was not the flight to Kigali. The mechanism was the letter. The notice of intent was, on its face, a simple document. It informed the recipient that the Home Office was considering declaring their asylum claim inadmissible and that removal to Rwanda was under active consideration. The recipient had either 7 or 14 calendar days, depending on their circumstances, to respond with reasons why their claim should not be treated as inadmissible. 7 days. For a person who had fled torture, who had survived bombing, who had watched family members die, who spoke limited English, who had no lawyer, who was living in a hotel room with strangers, 7 days to mount a legal defense against the machinery of the British state. And if they failed to respond, if they did not know how to respond, If they were too traumatized to respond? If the letter arrived on a Friday before a bank holiday weekend, as many did, giving them effectively no time at all? Then the notice stood. Their claim would be declared inadmissible. Their case would be placed in a legal limbo from which there was no clear exit. They would become, in the cold terminology of the Home Office, a withdrawn case, erased from the active asylum caseload, even as they remained physically present in the United Kingdom. One refugee charity described the effect with brutal clarity. Every single one of these asylum claims were unnecessarily put on hold by these notices of intent, which have only had the effect of keeping people's lives in limbo. The legal concept of inadmissibility is not new. Under international refugee law, an asylum claim may be declared inadmissible if the applicant has a connection to a safe third country where they could reasonably have sought protection. The logic is straightforward. Asylum is meant to be a last resort, not a matter of choice. If you passed through France on your way to Britain, the argument goes, you should have claimed asylum in France. But the Rwanda policy weaponized this concept. It declared that all irregular arrivals, regardless of their journey, regardless of their circumstances, regardless of the dangers they had faced, could be treated as inadmissible and removed to Rwanda, a country the government insisted was safe, despite overwhelming evidence to the contrary. The Home Office guidance was explicit. Asylum claims could be declared inadmissible where an individual was considered to have a connection to a safe third country. And the government had decided, as a matter of policy, that Rwanda was such a country. But there was a catch. The guidance also stipulated that asylum claims could only be held to be inadmissible where there was a reasonable prospect of removal within a reasonable period to a safe third country. In most cases, agreement with a safe country to admit an asylum seeker's claim should be obtained within 6 months of registration. This provision was meant to protect asylum seekers from precisely the kind of legal limbo that the Rwanda policy would create. If removal could not be effected within a reasonable time frame, the claim must be admitted for consideration in the UK. The Home Office ignored this provision. Thousands of asylum seekers remained in the third country process for significant periods of time, far longer than 6 months, unable to advance their asylum claim in the UK or seek protection elsewhere. They were, in the word used by lawyers, charities, and eventually Parliament itself, stuck in limbo. Between January 2021 and March 2023, the Home Office issued 24,083 notices of intent under the inadmissibility rules. These were letters sent to real people, people with names and faces and stories, people who had fled war and persecution and torture. Of those, data obtained by The Guardian through Freedom of Information requests revealed that approximately 18,078, nearly 3/4 of the total, were subsequently admitted into the asylum system. This is the number that matters. 18,078 people who were threatened with removal to Rwanda, who received that thin official letter with its 7-day deadline, whose cases were eventually allowed to proceed in the UK. But what of the remaining thousands? What of those whose notices were never overturned, whose cases remained in the inadmissibility process, who never received the letter that said their claim would be heard? After all, the Home Office did not release those numbers, but the pattern was clear. The Rwanda policy did not, in the end, send people to Kigali. Only 4 individuals were ever voluntarily relocated to Rwanda under the scheme, and no one was forcibly removed. What the policy did instead was create a vast administrative purgatory. Tens of thousands of asylum claims were paused, deferred, placed on hold, while the government pursued its legal and legislative battles over the safety of Rwanda. These claims were not refused. They were not granted. They were simply stopped, held in abeyance, erased from the active caseload, even as the people who made them remained in limbo. The word oath appears nowhere in the official documentation of the Rwanda policy. There was no formal oath that asylum seekers were asked to swear, no Bible placed in their hands, no pledge of allegiance demanded. But there was something that functioned as an oath in the deeper sense of the word, a binding commitment, a declaration of acceptance, a moment of choice that determined everything that followed. To be removed from the inadmissibility list, to have one's claim admitted to the UK asylum system, an individual had to do something. They had to respond to the notice of intent. They had to provide reasons why their claim should not be treated as inadmissible. They had to engage with the legal process, often without a lawyer, often in a language they did not speak fluently, often within a time frame that was manifestly inadequate. This was the hidden oath, the demand that asylum seekers prove their worthiness, their credibility, their right to be heard, on a schedule set by the Home Office under threat of erasure, and many refused. Not in the sense of a conscious political refusal, though some did refuse on principle, believing that no human being should have to beg for the right to seek asylum. But more often the refusal was passive, circumstantial, invisible. They did not understand the letter. They did not know they had to respond. They were too traumatized to read it. They were afraid that responding would make things worse. They had no access to legal advice. They did not know where to send their response. They responded, but the Home Office did not receive it. They responded, but the Home Office did not process it. In each case, the effect was the same. The notice stood. The claim remained inadmissible. The case was effectively erased from the system. The Home Office maintained a general pause in the making of inadmissibility decisions for much of this period, which meant that even when individuals responded, they received no decision. They were stuck. They could not advance their claim in the UK. They could not seek protection elsewhere. They could not work. They could not plan for the future. They could not live. The legal scholar who coined the term limbo in this context was not exaggerating. The state of being in the inadmissibility process was, by design, a state of suspension, a condition of neither here nor there, neither accepted nor refused, neither present nor absent. Asylum seekers in this position could not be removed to Rwanda because the policy was not yet operational. They could not be granted asylum in the UK because their claims were not being considered. They could not be refused asylum because no decision had been made. They could not be detained because there were no removal directions. They could not be released because they were already living in Home Office hotels. They were, in a very real sense, erased. Their cases existed in the Home Office's databases somewhere, but they were not being processed. They were not being counted in the active asylum caseload. They were not being factored into the government's statistics on backlog reduction. They were, for all practical purposes, invisible. And this invisibility was the point. The Rwanda policy was not designed to remove people to Kigali. The government knew from the moment the policy was announced that it faced insurmountable legal and practical obstacles. The first flight was grounded minutes before takeoff by an intervention from the European Court of Human Rights. The Supreme Court ruled in November 2023 that the policy was unlawful because Rwanda was not a safe country. The government responded by passing a law, the Safety of Rwanda Act, that required every decision maker, including the courts, to conclusively treat Rwanda as a safe country, regardless of evidence to the contrary. The policy was never about removal. It was about signaling. It was about deterrence. It was about creating the appearance of action while the machinery of government ground slowly forward. But for the people caught in that machinery, the effect was devastating. They were not deterred from coming to the UK. They were already here. They were not removed from the UK. They remained in hotels and hostels and temporary accommodation. They were not granted asylum. Their claims were not considered. They were not refused asylum. No decision was made. They were simply paused, held, waiting, erased. On November 15th, 2023, the United Kingdom Supreme Court delivered its judgment in the case of AAA and others versus the Secretary of State for the Home Department. The judgment was unanimous. The policy of sending asylum seekers to Rwanda was unlawful. The court's reasoning was devastating. Rwanda's asylum system had systematic defects that placed those removed there at real risk of refoulement, being returned to countries where they faced persecution or ill treatment. The evidence was overwhelming. Between 2020 and 2022, Rwanda had rejected 100% of asylum claims made by nationals of Syria and Afghanistan. The country had refouled at least 2 Afghans and 1 Syrian in 2022, returning them to the very dangers from which they had fled. The court was not persuaded by the government's assurances that Rwanda would honor its commitments. The structural and systemic failures in Rwanda's asylum system were too deep, too pervasive, too fundamental to be remedied by promises on paper. The government's response was immediate and defiant. It would not accept the court's ruling. It would not abandon the policy. Instead, it would do something unprecedented in British legal history. It would pass a law declaring that Rwanda was safe, notwithstanding the Supreme Court's finding to the contrary. The Safety of Rwanda Asylum and Immigration Act, 2024, received royal assent on April 25, 2024. It was, by any measure, a remarkable piece of legislation. It required every decision-maker, government ministers, immigration officers, courts, tribunals, to treat Rwanda as a safe country conclusively, meaning that no evidence to the contrary could be considered. The act effectively legislated facts out of existence. The Supreme Court had found, after a thorough examination of the evidence, that Rwanda was not safe. Parliament now declared as a matter of law that it was. Evidence that emerged in the future. Evidence that Rwanda had refouled more asylum seekers. Evidence that its asylum system had collapsed. Evidence that individuals sent there had been harmed, could not be considered by any court or tribunal. The decision was made. The facts were settled. Rwanda was safe because Parliament said it was safe. The UN High Commissioner for Human Rights, Volker Turk, condemned the act in the strongest terms. Settling questions of disputed fact, questions with enormous human rights consequences, is what the courts do, he said. You cannot legislate facts out of existence. The Act also restricted the application of the Human Rights Act, which provides legal effect within the UK for the European Convention on Human Rights. It rendered discretionary the implementation of interim protective orders from the European Court of Human Rights, orders that were internationally binding on the UK. It is deeply concerning to carve out one group of people, or people in one particular situation, from the equal protection of the law, Turk said. This is antithetical to even-handed justice available and accessible to all without discrimination. The act did not end the legal battles. It simply changed their terms. Asylum seekers who had received notices of intent continued to challenge their treatment in the courts. The grounds were novel and complex. Could Parliament truly compel the courts to ignore evidence? Was the act compatible with the European Convention on Human Rights? Could the government remove people to a country that the Supreme Court had found unsafe simply by declaring it safe? These challenges proceeded through the courts even as the government pursued its legislative agenda. The cases, known by the initials SM, SY, and Y, XY, encompassed challenges to the decisions to keep claimants in the Migration and Economic Development Partnership cohort, as well as broader structural safety challenges to the Act itself. But then, in July 2024, everything changed. A general election swept the Labour Party into power. The new Prime Minister, Keir Starmer, had campaigned on a manifesto pledge to scrap the Rwanda policy. On his first day in office, he declared the plan dead and buried. The government informed the court that no deportation flights were planned. The 3 individual claims were settled, with the Home Office agreeing to consider them in the UK. But the broader fate of the thousands of people still in the inadmissibility process remained unclear. By the time the Rwanda policy was finally abandoned, it had cost British taxpayers more than £300 million. Only 4 individuals had been voluntarily relocated to Rwanda. No one had been forcibly removed. But the cost in human terms was incalculable. Tens of thousands of asylum seekers had spent months, in some cases years, in a state of legal suspension. They could not work, could not plan, could not live. They were trapped in a system that had no exit because the policy that created their limbo had been designed not to function but to signal. And the government that had created the policy did not have to face the consequences. By the time the Labour government began the process of untangling the mess, the architects of the Rwanda policy were in opposition, free to complain that the new government was not moving quickly enough to resolve the very problems they had created. Isaro was a Rwandan national who fled to the United Kingdom to escape persecution. She was of Hutu descent. In Rwanda, that identity carried deadly weight. The 1994 genocide had seen Hutu militias kill more than 800,000 Tutsis. But after the Tutsi-led Rwandan Patriotic Front declared military victory, the tables turned. Hutus became the targets. They were criminalized, discriminated against, forced to flee. Isaro's husband beat her when he discovered she was Hutu. He raped her. The beatings continued through her pregnancy, causing her to miscarry. "I was in a dark place. I wished I could die," she told a reporter. "I didn't know whom to tell because the government doesn't care about Hutus." She fled to the UK in 2022. She applied for asylum. She waited. And then she learned that her own country, the country she had fled for her life, was being declared safe by the British government, safe enough to send other asylum seekers to. Rwanda is not a safe country, she said. Not only for refugees, but also for Rwandans. Things are getting worse. We have social problems, economic problems, and human rights are being violated every day. The irony was bitter and inescapable. The British government was simultaneously granting asylum to Rwandans like Izero. At least 4 were granted refugee status in the UK over well-founded fears of persecution by the regime, while arguing in court that Rwanda was safe for other asylum seekers. The Home Office's handling of the Rwanda policy was not merely cruel, it was incompetent. A High Court judgment examining 8 individual cases found 19 decisions that were legally flawed and ordered the Home Secretary to retake them. The court found that the Home Office had made errors in each of the 8 cases, ranging from failure to consider relevant evidence to outright legal misdirection. In some cases, the Home Office withdrew removal directions only after further evidence or court proceedings forced its hand. In others, the office simply failed to make decisions at all, leaving individuals in limbo for months on end. The Information Commissioner opened an investigation into the Home Office's handling of asylum cases, citing utter incompetence and inability to process cases properly. The Home Office had managed the astonishing feat of creating an asylum system that was simultaneously slow, expensive, shoddy, and in some cases, unlawful. Perhaps the most disturbing revelation came in the government's own impact assessment. More than half of the asylum seekers allocated for removal to Rwanda could not be found by the Home Office. Almost 6,000 people were due to be issued notices of intent, but just over 2,000 were able to be tracked down. Thousands of people, real people with names and faces and stories, had simply disappeared from the Home Office's view. They had moved, perhaps, changed their contact information, fallen through the cracks of a system that was never designed to hold them. Where were they? Living in the community, presumably? Working cash jobs, perhaps? Hiding, maybe? Some may have left the country voluntarily. Some may have died. The Home Office did not know, and did not seem particularly interested in finding out. These were the truly erased, not just their cases, but their very existence, wiped from the government's records, lost to a system that had never intended to accommodate them in the first place. When Keir Starmer's Labour government took power in July 2024, it inherited a catastrophe. The Rwanda policy had cost hundreds of millions of pounds, produced no results, and left tens of thousands of asylum claims in a state of legal paralysis. The new government moved quickly to scrap the policy. On its first day in office, it announced that the Rwanda scheme was terminated. The Home Secretary, Yvette Cooper, called it the most shocking waste of taxpayers' money I have ever seen. But scrapping the policy was not the same as undoing its effects. The thousands of notices of intent that had been issued did not simply disappear. The cases that had been placed in the inadmissibility process did not automatically resume. The people who had been living in limbo for months or years could not simply be granted asylum overnight. The Labour government faced a choice. It could attempt to process all the backlogged claims quickly, granting asylum to those who qualified and removing those who did not, or it could continue the previous government's approach of administrative inertia, allowing the backlog to persist indefinitely. Early indications suggested a mix of both. The government announced that it would focus on restoring order and control to our borders, including removing the incentives, drawing illegal migrants to Britain, and scaling up removals of those with no right to be here. but it also acknowledged that the asylum system was broken and that fixing it would take time. On June 1st, 2026, the Permanent Court of Arbitration in The Hague delivered its ruling. Britain would not have to pay Rwanda the more than £100 million that Kigali claimed was still owed under the collapsed asylum deal. The tribunal ruled that the UK was not liable for the outstanding payments, which Rwanda had sought as compensation for costs incurred preparing for a scheme that never materialized. Britain had already paid Rwanda approximately £290 million to cover the costs of hosting the scheme before the Labour government terminated it. Rwanda's case was that it had shouldered considerable costs up front only for the UK to seek to walk away from its legal obligations without advance notice. But the tribunal rejected this argument, ruling in favor of the UK on all grounds. For the British government, it was a vindication. For Rwanda, it was a defeat. And for the people caught in the middle, the asylum seekers who had spent years in limbo, it was a reminder that the policy had always been about money and politics, never about human beings. As of 2026, the full extent of the damage caused by the Rwanda policy is still being measured. The 24,083 notices of intent represent 24,083 human stories, each one a life interrupted, a future delayed, a hope deferred. Some of those stories have happy endings. More than 18,000 people have since been admitted into the UK asylum system and are having their claims processed. Some will be granted refugee status, some will be allowed to stay, some will build new lives in Britain, find work, raise families, contribute to their new communities. But others remain in limbo. Others have been refused. Others have been removed, not to Rwanda, but to their countries of origin, where danger and persecution may await. Others have simply disappeared, lost to a system that never cared enough to find them. The Rwanda policy was, in the end, a failure by every measure. It failed as a deterrent. Small boat crossings continued throughout its existence. It failed as a policy. No one was ever forcibly removed to Rwanda. It failed as a legal strategy. The Supreme Court struck it down, and the act designed to revive it was condemned by international human rights bodies. And it failed as a humanitarian exercise. Thousands of vulnerable people were subjected to months or years of legal uncertainty, psychological distress, and administrative neglect. But perhaps the greatest failure is the one that cannot be measured in statistics or court rulings. The Rwanda policy represented a deliberate choice by the British government to treat asylum seekers not as human beings fleeing persecution, but as problems to be managed, numbers to be reduced, bodies to be moved. And that choice, more than any policy decision, is the true erasure. Erased. The word appears nowhere in Home Office guidance. It is not a term of art in immigration law. It is not found in the Safety of Rwanda Act or the Illegal Migration Act or any of the other legislative instruments that created the policy, but it is the word that asylum seekers and their advocates use because it captures something that the official language obscures. To be in the inadmissibility process is to be in a state of suspension, neither here nor there, neither accepted nor refused, neither present nor absent. It is to exist in the system but not to be processed by it. It is to have one's case recorded but not considered, counted but not valued. This is erasure, not the violent erasure of death or deportation, but the quiet erasure of neglect, the erasure that comes from being deemed not worth the time, not worth the attention, not worth the effort of a decision. The Home Office claimed that it could not process these cases because it was waiting for the legal challenges to resolve, waiting for the act to pass, waiting for Rwanda to be declared safe. But the truth is simpler and more damning. The Home Office did not process these cases because it did not have to. The individuals in the inadmissibility process had no political power, no media attention, no advocate in the halls of Westminster. They were invisible, and, invisibility is the precondition of erasure. Every asylum seeker who received a notice of intent faced a choice. They could respond to the notice, providing reasons why their claim should be heard in the UK, or they could remain silent. This was not a real choice. For most, the notice was incomprehensible, written in dense legal English, referencing statutes and regulations they had never heard of, demanding a response within a time frame that was absurdly short. For many, there was no one to help them understand it. Legal aid for immigration cases had been gutted years ago. Pro bono lawyers were overwhelmed. Charities were underfunded and overstretched. To respond required resources that most asylum seekers did not have: time, money, legal knowledge, English fluency, access to a printer and a postbox. To respond required a level of psychological resilience that most people fleeing torture and persecution could not muster. To respond required believing that the system would listen, a belief that experience had taught many to abandon. So they did not respond. Not because they refused the oath, but because they could not take it. And the system used their silence against them. Failure to respond was treated as acquiescence, as evidence that the notice had been received and understood, that the individual had no objections to removal, that the case could proceed to inadmissibility. This is the cruelty at the heart of the Rwanda policy. It demanded everything from people who had nothing, then punished them for failing to deliver. The Safety of Rwanda Act has since been repealed. The Border Security, Asylum and Immigration Act, 2025, formally ended the UK's migration agreement with Rwanda and removed the Safety of Rwanda Act from the statute books. The policy that caused so much suffering is now officially a dead letter. But the reckoning has not come. No minister has been held accountable for the £300 million wasted. No official has been disciplined for the incompetent handling of cases. No apology has been issued to the thousands of people whose lives were placed on hold for years. The government has moved on. The media has moved on. The public has moved on. The Rwanda policy is now a historical footnote, a curiosity from a previous administration, a cautionary tale about the limits of deterrence. But for the people who lived through it, the erasure continues. Their cases may have been admitted to the asylum system, but the damage has been done. Years of limbo have taken a toll that cannot be measured in statistics. Relationships have fractured. Mental health has deteriorated. Children have grown up in hotel rooms, unable to attend school, unable to make friends, unable to plan for a future that never seems to arrive. The Rwanda policy may be dead, but its legacy lives on in every person who received a notice of intent. Every person who spent months in inadmissibility limbo, every person whose case was erased. Birmingham, England, June 2026. Amina received the letter that changed everything on a Tuesday afternoon, 2 years after the first notice arrived. Decision on admissibility. Your asylum claim has been admitted for consideration in the United Kingdom. She read it 3 times, just as she had read the first notice. But now she was not trembling with fear. She was crying with relief. 2 years. 2 years of living in a hotel room. 2 years of not knowing whether she would be allowed to stay. 2 years of watching her children grow up in a place that was not home. 2 years of being erased. But now the erasure was over. Her case would be heard. Her voice would be listened to. She would have her day in court, her chance to tell her story, her opportunity to prove that she was not a statistic or a problem or a body to be moved, but a human being fleeing persecution, seeking safety, hoping for a new life. She did not know if she would be granted asylum. She did not know if she would be allowed to stay. She did not know if her children would grow up British or be sent back to a country that might kill them. But she knew one thing. She was no longer erased. She existed. Her case existed, her story existed, and that, after 2 years of nothing, was everything. The Rwanda policy raised many questions about the limits of parliamentary sovereignty, about the role of courts in protecting human rights, about the ethics of outsourcing asylum processing to third countries, about the effectiveness of deterrence as a migration strategy. But one question towers above the rest. What does it mean to be a human being in the eyes of the state? The government's answer throughout the Rwanda policy was clear. Asylum seekers were not human beings with dignity and rights. They were problems to be solved, numbers to be reduced, bodies to be moved. Their stories did not matter. Their fears did not matter. Their lives did not matter. The government made this answer explicit in the Safety of Rwanda Act, which required all decision makers to treat Rwanda as safe regardless of evidence. The government was saying, in effect, we do not care what is true. We care what we have decided. And our decision is final. This is the erasure that the Rwanda policy represents. Not the erasure of people from a database, but the erasure of the idea that people matter, that their suffering counts, that their voices deserve to be heard. The policy is dead. The law has been repealed. The government has moved on. But the erasure continues every day, in every decision that treats human beings as problems, every law that prioritizes administrative convenience over human dignity, every moment that the state looks at a person fleeing persecution and sees not a person but a number. The question is whether we, as a society, will continue to accept this erasure, whether we will demand better of our government, whether we will insist that every person, regardless of how they arrived, regardless of where they came from, regardless of what language they speak, deserves to be seen, heard, and treated as a human being. The Rwanda policy was a failure, but it was also a choice, and we can choose differently.